Hi guys, welcome to my next bAIgel episode. My today guest is Dr. Julian Potter, partner of WP Thompson, very renowned UK patent attorney, and also member of the board of our common iTech Law Association. So Julian, welcome.
Thank you, Michael. I'm looking forward to our chat.
We are here to discuss the legal framework of the UK about IP rights and AI. So, can you tell us briefly in few words how it looks like?
The AI is a piece of software, and we cater for software under the UK Patents Act 1977 to the extent that a computer program is not considered to be an invention as such. And those words as such, as you might imagine, have taken on great import under English law when it comes to the patentability of software. AI falls under that. And the basic requirements are that there has to be some kind of technical effect that the software runs or produces outside of merely running on a computer. So the fact that a computer has electrons running inside it is not the technical effect that's required. An example of a technical effect would be something that controls a piece of apparatus, maybe a nuclear power station, maybe an X-ray machine or something like that has an external effect. Or there is a technical effect within the computer itself, such as managing memory in a certain way to reduce the use of memory or the use of power or something like that. That's the kind of technical effect we're looking for. So AI has to fulfill those requirements.
Okay, it sounds great that you're prepared since over 40 years to AI, but it's a kind of software, but really strange or new kind of software. Are there any new judgment or recent comments?
Well, the key judgment that is running forward at the moment is actually on computer-generated works. And this is the Dabus, Dabus case, where two patent applications were filed and the inventor was named as a machine, the machine Dabus. The filing has been rejected because an inventor was not properly named, the inventor having to be a human being. And this goes down to the nature of the ownership of property under English law, where you have to be a legal person, whether you're a natural person or a corporate entity, which has rights under English law to own property and other certain entities. The result of this was that the Patent Office rejected it. An appeal was made from the Patent Office to the High Court. They upheld the Patent Office decision. Appeal went to the Court of Appeal, where the decision was upheld, although there was a crazy dissenting comment or concerns expressed by one of the judges, and permission to appeal to the Supreme Court was granted. The case was heard earlier this year, around about June, summertime, and we're now awaiting the decision of the Court of Appeal, of the Supreme Court. And though we've had the summer recess, of course, I think the length of time it's taking to issue the judgment indicates the difficulty and, of course, importance of the question put. So that is where we are on the patent law. What is interesting is that the 1988 Copyright Designs and Patents Act, which was derived from, I think, the Whitford Committee back in the late 60s as they're looking at copyright law then, that has a section in relation to works generated by a computer. This is for copyright. And there, and I'm precising this, I'm summarizing, which is not always the best thing to do with the law, but for the purposes of 10 minutes breakfast bagel, then we can. It is the person who makes the arrangements for the generation of the computer-generated work, that is designated the author. They have to be designated the author because under English copyright law, the author is the first owner of the copyright. That definition does leave open questions as to what is making the arrangements. What does that mean? If I own it and say print something on it, which was computer generated, I own the computer that produces the work, am I the author? Or maybe you, who might have been the software engineer who developed the software that produces the work, should you be the author? These questions haven't been answered yet, haven't actually been asked. To be fair, I think that was definitely a piece of legislation that was way beyond its time.
2 weeks ago, I discussed the patentability with one of the Berlin researchers. We discussed how AI should influence changes or reinterpretation of European law. What do you think? What are comments in UK legal
Well,
world?
this is interesting. I think it draws between the notion of a common law jurisdiction, which is what the UK is, and the more civil code jurisdiction in Europe.
Yes.
We can have judge-made law and set precedent, and I think that might be the right way to do it. Philosophically, I'm opposed to making lots of different laws for very specific circumstances, because I think that actually creates conflicts of laws if you're not careful. I know in Europe and at the Commission level, lots of work is going on in AI. The question of the ownership of an invention is likely to be a matter for national law. Now, whether that's directed by regulation or direction from the EU or left to national law is a matter for the European Union, of course. What I would caution against is creating a completely new legal regimen, because I think what I've always been impressed with the laws relating to technology is how laws made 40 years ago, with the right judges, people who are prepared to think carefully, can adapt the law and develop the law to cope with the new technology, even though there's technologies that were never conceived of. And the reason why I particularly like that is because the judges should be reflecting society. And so as society develops, they develop the law to reflect the society in relation to the new technology. They don't always get it right, but again, I recognise that may be a philosophy that somebody from a common law jurisdiction may feel more comfortable with, looking towards a civil jurisdiction where there may be a tradition of defining what you want. I think fundamental questions just need to be asked, and IP is fundamentally a commercial tool. So you start with the needs of commerce. The ownership of AI generated works is important because business is not going to invest in something that they can't own and control. So this is a serious question. It's not an abstract question. And so that's where I'd say look at the ownership. Why do you want the ownership? You want business to be able to acquire it. And starting from that position, that may inform how you create new laws or interpret existing law.
One last question. 2 weeks ago, when I discussed this patentability with Peter Slovinsky, I asked him if I prompt just 2 words and get a full code of software, or I get a very precise, ready to publish picture or film, is it still a tool? What's your idea? What's your position? If my input is very small and I get very, very huge output, is it still a tool or a kind of co-creator?
Well, first of all, I think it is a tool, and I think it always requires human supervision. I think this goes to the responsible use of AI anyway, so that's my basic philosophy. Looking at your question in particular, if I have a machine that makes a favorite biscuit of mine, the Jaffa biscuit, the chocolate-coated marmalade biscuit, or is it a cake? We don't know. Well, people argue that, but I have a machine that makes Jaffa biscuits, and there's a big green button, and I press that green button and it makes lots and lots of Jaffa biscuits. Is it creating them, or is it a tool? I think it's a tool. As it moves on, maybe the issues will be more difficult to define, and if we get to sort of cognitive AI, quantum cognition, that enters a whole new world. I think we are a long way off from that, but I think we are probably on the path to that, leading to that eventually. And these thoughts and considerations, both from an ethical and social responsibility point of view and a legal point of view, because ultimately the law tries to implement social and ethical responsibilities, are very important to start thinking now, because they're complex topics.
Okay, thank you very much. So AI like a biscuit machine. It's a good final word of our podcast. Great, you joined me. Thank you for the discussion, and you guys join our episode and next episodes each Monday. Thumbs up, subscribe, and see you later on. Bye bye.
Bye. Thank you, Michael. Excellent.